processing titles and selling them to third parties. C. Registered proprietors selling land to more than one person, then acquiring a special certificate of title to defeat the purchaser's interest. Children relatives stealing titles from their parents and hide them and then claim that titles are lost. As a result, of these many complaints, we have initiated extra administrative measures, such as submission of police reports, confirming loss of a title, and to enable for any potential criminal liability as a result of misrepresentation of the facts by the registered owners. Physical appearance of the registered owners for identification with their national ID, and local council introduction letters, local council 1. The Land Information System has also initiated protection measures through sending messages or alerts to registered addresses and phone numbers of registered owners. The only challenge here, at times, Ugandans want to trust their lawyers a lot, so the lawyers' numbers are the ones that are registered, all blockers. And when an alert message is sent, of course it doesn't come to you as an individual, it goes to the registered number. But now we are encouraging them to make sure that their numbers are always given, such that when the alerts are sent, they go to the right person for proper identification and rectification of what has been identified by the registrars. The linkage with NIRA to identify registered owners with their names is also taken into consideration. However, although the law specifically requires gazette notice, not so many Ugandans actually read the gazette. So it may be argued that the risk mitigation measure of informing the world about the application may not be effectively adequate. Therefore, this is to advise that in addition to these measures we are putting in place, you may also consider a newspaper advert for wider circulation to enable us to get to as many objections as possible, if any. Then registrars are also expected to do due diligence before final issuance of special titles by consulting the local leaders on ground to make sure that at least that extra due diligence is done. Because once a title is printed, then it will be used as a legal document to confirm proof that the other title actually is non-existent or got lost. Further, any physical objection to creation of a special certificate of title should be addressed to the Ministry's Zonal Office. Registrars of titles who have issued the notice, this shall enable the issuing officer to be alerted as soon as possible, thus avoiding the delays of letters being posted to the ministry headquarters. This is in line with the ministry's decentralization policy on land registration in Uganda. We are prioritizing inspection reports as internal part of the first registration. As custodian of the land register, it is important to emphasize the value of land inspections to ensure the integrity of the land registration process. Land inspection provides information and insights into the registration process. It also involves visual inspections, measurement and research to ensure that there is compliance with the legal regime, to minimize registration irregularities, but also inaccuracies in ownership records in the ministry. The Office of Titles has received numerous petitions of sitting tenants, customary owners requesting for cancellation of titles on the ground that a title registration facilitation process did not comply with Section 64 of the Land Act and Registration and Regulation of the Land Regulations 2004. And in particular that the area land committees do not visit the land have a record of the proceedings and adjudicate the land rights to ensure that the applicants are the non-registered landowners. Similarly, the district land boards are also supposed to comply with the Physical Planning Act, which makes Uganda entire planning area. Section 9 of the Act establishes the District Planning Committee, which is chaired by the CAO as a member, but there are also other members like the district planner, the environmental officer, the surveyor, and an engineer. So we expect them to go on ground, assess, and give a report, which report will validate what our registrars have. The technical officers of the District Physical Planning Committee under the Chief Administrative Officers should facilitate and mitigate the errors of the Area Land Committee. Because if the Area Land Committees have made errors, then we expect this Superior District Land Board to at least see those mistakes that have been made by the Area Land Committee, and at that particular time rectify what has been made by the Area Land Committees. Because much as we are doing physical planning, but we need also to take care of our wetlands, the forest reserves, and other natural resources. We need to protect them at this level. Once we miss them at the level of physical planning, then they may not be captured at all. You might find that they are subdivided and put on somebody's title. But if that has been rectified, then the title will be a very good title. This implies that the District Planning Committee, chaired by the CAO, is vital in ensuring that there is compliance with the legal requirements and that the allocations made protect the environmentally sensitive areas. Therefore, the land officers at the ministerial zonal offices should ensure that on every fresh allocation, all these processes and procedures are followed. The minutes of the District Land Board should be verified. And if the board is satisfied that everything has been complied with, then they would have met the requirements of the law and the requirements of the land regulations of 2004. On leases that the land officer, secretary of the land board, district surveyor has inspected the land, perused through the topo maps and cadastre, and certified that themselves that the land is available for leasing through their inspection report. The District Physical Planning Committee, they have also the mandate again to visit and satisfy themselves on the land usage, the zoning, but also to be very clear that the land has no occupants, all owners, all tenants. Because we have been having cases where somebody gets land or gets a title on land where they have no chibanja or they have no activity at all. And yet that land is highly encumbered, has people who are seated on it, they are doing activities, only that their interests have never been registered. Then somebody who got an opportunity somehow works out their way and they get a title, and this has been causing confusion in society. On consultation with the ministry, I have also been advised that in addition to the above, all the first registration of 250 hectares in rural areas and 10 hectares in municipalities and cities and above, they should be inspected by registrars of title before registration. Before, they have been waiting for the entire process to be done by the districts and the respective officers on ground. But now, as another way of protecting the interests on land, they have to make sure that once land exceeds those acreage or hectares, they have to make sure that further due diligence is done by physically inspecting those pieces of land. to confirm that there is no dispute, there is no title, at least it is free of any encumbrances. On conversion of blue pages to white pages, the field officers should be able to indicate in a survey report as to whether the applicant is in physical occupation or not. And if the applicant is not in possession, then any conversion to white page is subject to the unregistered interests on the land. You cannot totally convert a blue page where there are people. If there are people, those interests have to be taken into consideration before a title is made. And for land on blue pages, whose landowners are not known by the tenants and have never appeared on that piece of land, the sitting occupants may apply for title by possession direct, subject to the law and other due diligence procedures. Comprehensive land inspection shall enable us validate customary claims and ensure that information recorded in our registry is undisputed. Such proactive actions will help prevent future conflicts, ensure legal compliance, and address potential irregularities at the onset. Thus, we will save time and the unnecessary litigations. However, of recent, LCs are getting involved in the mapping and registration of land. This is the role of the area land committees, which are based at the sub-county level. The LCs must not get involved in the selling of land which does not belong to them. They can only be witnesses. They can only confirm that we know these people, they have been staying on this piece of land, but where they participate in the sales of land which does not belong to them, it becomes illegal. It is an illegal practice. They have only to witness and confirm the occupants. Why are we saying this? We have been getting reports where LCs find land that belongs to government or public land, and they begin acting as owners. When they act as owners, they make sales agreements for the parties who are purportedly buying that piece of land. So it is not allowed and it is not anywhere in the law. They can help us because they are the opinion leaders on ground to verify, to witness, but also confirm that we know this mutaka, we know these tenants, they have been on this piece of land. That is what we want them to help our officers with on ground. And they can work with the area land committees, because area land committee at a sub-county, that is at a bigger level. But where a dispute is at a village or in a parish, the area land committees can work with the LCs to make sure that accurate information comes out from the ground to enable them make an informed process or conclusion of the matter.